Before we begin, it's crucial to understand that the information provided in this video is for general informational and educational purposes only. It is not a substitute for professional legal advice. I am not an attorney, and this presentation does not create an attorney-client relationship. The hiring of a lawyer is an immensely important decision that should not be based solely on the content of this video. You should always consult with a qualified, licensed attorney in your jurisdiction for advice on your specific situation. He was the perfect lawyer. At least that's what Sarah thought. Her small online business, her passion project for the last 5 years, was being threatened by a frivolous lawsuit from a massive competitor. She was terrified. She found a lawyer online with a sleek website, a corner office, and a handshake that felt like it could crush steel. He talked a big game, promising to make the problem disappear. The price was steep, but he said, "You can't put a price on peace of mind." So she paid. And then the calls started going to voicemail. Emails went unanswered for weeks. Deadlines were missed. The aggressive strategy he promised turned into a panicked, last-minute settlement offer that basically gave the competitor everything they wanted. Sarah lost a huge chunk of her business, and she was thousands of dollars in debt to a lawyer who had ghosted her. It was only after the damage was done that she did some digging and discovered the truth. This perfect lawyer had a history, a documented trail of professional misconduct, client complaints, and 2 prior suspensions from the state bar for the exact same behavior: taking money, making promises, and then completely neglecting the case. Sarah's story is devastating, and it is shockingly common. According to the American Bar Association's most recent data, tens of thousands of formal complaints are filed against attorneys by the public every single year. And let's be honest, that's just the fraction of people who have the energy and knowledge to navigate the formal complaint process. The real number of people left feeling burned, broke, and betrayed by the person they hired to protect them is exponentially higher. Hiring a lawyer is one of the most consequential decisions you will ever make. This isn't like picking a bad restaurant. The person you choose to represent you in a divorce, a criminal case, a business dispute, or a personal injury claim holds your financial future, your freedom, and your family's well-being in their hands. The stakes are astronomical. So how do you separate the true advocates from the slick-talking predators? How do you look past the paid-for awards on the wall and the 5-star Google reviews to see the truth? That is exactly why I made this video. We are going to pull back the curtain. I'm going to give you a step-by-step, investigator's guide to conducting a deep-dive background check on any lawyer in the United States. And the best part? Every single tool and strategy we're going to cover is completely free. We're not just scratching the surface with a simple Google search. We are going deep. By the time you finish this video, you will have a rock-solid system to vet any attorney you're thinking of hiring. You will know precisely where to look, what to look for, and what the red flags are that should have you running for the door. This is about giving you the power to protect yourself, to make an informed decision, and to hire with absolute confidence. Most people make 3 critical mistakes when hiring a lawyer. The first is what I call review gazing. They go on Google or Yelp, see a bunch of 5-star reviews, and think they've done their homework. But here's the reality. Reviews can be bought, they can be manipulated, and they are often written by clients right after a win, before they've even gotten the final bill. A glowing review won't tell you if the lawyer was sanctioned by the state bar last year for mishandling client funds. The second mistake is blind reliance on a referral. Your friend says, "Oh, you have to use my lawyer, he was great for my traffic ticket." That's wonderful. But that doesn't mean he's remotely qualified to handle your complex custody battle or a multi-million-dollar real estate transaction. The skills are not transferable. The third and most common mistake is simple intimidation. People are afraid to ask tough questions. They feel like they're questioning the doctor about his medical degree. You have to get over this. You are the employer. You are the one writing the check. You are hiring them for a service, and you have every right to vet them thoroughly. To do this right, we need a system. I call it the 3 pillars of vetting. It's a simple framework that ensures you cover all your bases. Pillar number 1 is the official record. This is the absolute, non-negotiable foundation of your search. We're talking about their license to practice and, more importantly, their disciplinary history. This is where you find out if they've ever been formally punished for misconduct. Pillar number 2 is the professional reputation. This is what the official record can't tell you. Is this lawyer respected by their peers? Do judges think they're competent? Or do they have a reputation for being lazy, unprepared, or a bully? This is the insider information you have to find. And pillar number 3 is the digital footprint. This is where we go beyond their curated website and LinkedIn profile to see what the rest of the internet says about them, in court filings, in news articles, and in their own online activity. Today we're starting with the most important pillar of all, the official record. This is your first stop always. Before you even pick up the phone to schedule a consultation, you need to do this. Every single lawyer who practices in the United States must be licensed by a state bar association. This is the official governing body that sets the ethical rules and, crucially, disciplines lawyers who break them. Your mission is to go to your state's bar association website and look up this lawyer. It's incredibly easy. Just open a new tab right now and Google the name of your state followed by State Bar Association. So, Texas State Bar Association or California State Bar or Florida Bar. Once you're on the site, you're looking for a directory, usually labeled Find a Lawyer, Attorney Search, or Member Directory. Click it and type in the full name of the attorney you're considering. The first thing you're going to check is their license status. It should say something like active and in good standing. That's the baseline. If it says anything else, that's a giant red flag. Inactive could mean they've retired, but it could also mean they're not currently eligible to practice. Suspended means they have been temporarily banned from practicing law because of a serious ethical violation. Disbarred is the death penalty for a lawyer. It means they've been stripped of their license permanently for egregious misconduct, like stealing client money or committing a felony. If you see suspended or disbarred, your search is over. End of story. Do not walk, run. But let's assume it says active. Your work isn't done. Now you need to look for the gold, the disciplinary history. This section might be called Discipline, Public Record, or Record of Public Discipline. This is where the Bar Association posts any public sanctions against the lawyer. If this section is empty or says no record of public discipline, that's a great sign. But if there is something there, you need to read it carefully. Discipline comes in several flavors. A private reprimand is a slap on the wrist that isn't usually public. A public reprimand or censure is a formal public scolding for misconduct. A suspension, as we discussed, is a temporary ban. You need to look at two things: the severity and the substance. What did they actually do? Was it a one-time technical mistake on a filing from 10 years ago? Or is there a pattern of behavior? For example, if you see a public reprimand from 2019 for failure to communicate with client, and another one from 2022 for lack of diligence, you're seeing a clear pattern of a lawyer who neglects their cases and their clients. That is a massive red flag that their slick website will never tell you about. These public records will often include a link to the actual court documents or a summary of the case. Read them. Find out exactly what happened. This isn't just about finding a clean record. It's about understanding the character and professionalism of the person you're about to trust with your life's problems. One more critical point on this. Lawyers can be, and often are, licensed in more than one state. A lawyer who just moved to your state might have a perfectly clean record there, but a disastrous history in the state they just left. So you have to ask them, what other states are you licensed in, or have you ever been licensed in? Then, you must repeat this exact process for the State Bar Association of every single one of those states. It takes an extra 10 minutes, and it could save you from a world of pain. A clean record from the State Bar is the absolute minimum requirement. It's just the price of entry. It proves they haven't been caught for major professional crimes. But it doesn't tell you if they're actually a good lawyer. It doesn't tell you if they win cases, if they are respected by judges, or if opposing counsel fears them. That clean record tells you they know how to follow the rules. It doesn't tell you if they know how to win. And finding that out requires us to dig into our second pillar, uncovering their professional reputation from the people who know them best. That clean record tells you they know how to follow the rules. It doesn't tell you if they know how to win. And finding that out requires us to dig into our second pillar, uncovering their professional reputation from the people who know them best. And when I say the people who know them best, I'm not just talking about their mom or their best friend from college. I'm talking about the people who see them in the arena, the opposing lawyers who have gone to war with them, the judges who have presided over their cases, the clients who have trusted them with their lives and livelihoods. Their reputation within this ecosystem is one of the most powerful predictors of their actual skill. A spotless disciplinary record is the floor. A stellar professional reputation is the ceiling. So where do we start? We start with the gold standard, peer review ratings. These are evaluations made by other lawyers and judges. This isn't about a slick website or a fancy commercial. This is about what their direct competitors and the referees of the legal world think about their ability. The undisputed heavyweight champion in this space is Martindale-Hubbell. They've been rating lawyers for over 150 years, long before the internet even existed. Their top rating is called AV Preeminent. This rating is pure gold. Let me break down why. The A represents legal ability, meaning their peers rank their skills at the very top. The V stands for very high ethical standards. When a lawyer has an AV Preeminent rating, it means that a significant number of their peers, the very people they battle against in court, have anonymously told Martindale-Hubbell. This person is an elite lawyer, and they operate with the highest integrity. Think about that. It's like asking a team of NFL coaches to secretly vote on the best quarterback in the league. When they all point to one person, you listen. An AV-rated lawyer is respected by their adversaries. They're seen as formidable, ethical, and highly skilled. A lawyer without this rating isn't necessarily a bad lawyer, but a lawyer who has it has earned a level of respect that is incredibly difficult to achieve. It's a massive green flag. Then you have services like super lawyers and best lawyers. These are also peer-influenced. To be selected for super lawyers, for example, a lawyer has to be nominated by their peers, then vetted by an independent research team, and then evaluated by a panel of top attorneys in their same practice area. The final list represents no more than 5% of the lawyers in the entire state. So, if your potential lawyer is on that list, it signals they are highly regarded by the people who know their work intimately. It's another powerful data point suggesting you're dealing with a serious professional. But peer reviews are just one piece of the puzzle. They tell you what the experts think. Now we need to find out what their actual clients think. This is where we turn to online legal directories like Avu, Justia, and FindLaw. Let's focus on Avu for a moment because it offers a few unique tools. First, you have the Avu rating, a score from 1 to 10. Unlike Martindale, this isn't a pure peer review. It's an algorithm that tries to assess a lawyer's background based on the data it can find: years in practice, disciplinary history, professional achievements, and industry recognition. A high Avu rating is good, but it's the client reviews on these platforms that can provide a treasure trove of information if you know how to read them. And this is critical. You cannot just look at the star rating. Reading lawyer reviews is a skill. A 1-star review from a client who lost their case might just be sour grapes. A 5-star review that just says they were great is useless. You are looking for patterns and details. Ignore the emotional outliers and hunt for the specifics. Scroll through dozens of reviews, both positive and negative. Are you seeing a pattern? For example, do multiple clients mention that the lawyer was a terrible communicator, or that they never got back to me? That's a huge red flag. An unresponsive lawyer is one of the biggest complaints in the industry. Conversely, if you see 10 different reviews all saying, "Even when the news was bad, they called me immediately and explained everything clearly," you found someone who values communication. Look for reviews that describe the process, not just the outcome. A review that says, "We went through a tough 2-year battle, and Attorney Smith's office kept us informed every single step of the way. Their paralegal, Sarah, was amazing and always knew the status of our file." That review is worth more than 10 reviews that just say, "We won." Winning isn't always possible, but professionalism, organization, and communication are. You are hiring them for a process, and the review should give you a window into what that process will feel like. So, you've checked the peer reviews and you've analyzed the client reviews. You're building a strong picture. Now it's time for an advanced technique, what I call tapping into the courthouse whisper network. You can't just call up a judge and ask for their opinion on a lawyer, but the legal system leaves clues about who it trusts. One of the biggest clues is leadership in professional organizations. Is the lawyer the president of their local or state bar association? Do they chair an important committee like the ethics committee or the family law section? This is not just resume padding. To be elected to these positions, a lawyer needs the votes and the respect of hundreds, sometimes thousands of other lawyers. It means their peers trust their judgment, their leadership, and their character. It shows a commitment to the profession beyond just their own caseload. It's a sign that they are a pillar of the legal community. Another powerful clue is if they are court-appointed. In certain complex cases, a judge will need to appoint a neutral lawyer to act as a special master, a mediator, or a guardian for a child. Judges don't pick these lawyers from a hat. They appoint the lawyers they know to be experienced, trustworthy, and incredibly competent. If you find out your potential lawyer is frequently appointed by judges to handle sensitive matters, you've just discovered that the judiciary itself holds them in the highest esteem. That's an endorsement you simply can't buy. Now, you personally might not be able to see this next part in action, but I want you to understand the concept. Imagine walking into a courthouse and watching how the staff, the clerks, the bailiffs, the judicial assistants interact with a lawyer. These people are the gatekeepers and the gears of the entire justice machine. They see lawyers at their best and at their absolute worst. They see the unprepared lawyer who is always filing things at the last minute and treating the staff rudely. And they see the professional who has their documents in perfect order, treats everyone with respect, and knows the rules. There's often a subtle eye roll for the first lawyer and a warm, efficient nod for the second. A lawyer who has a good reputation with the court staff is almost always a lawyer who is prepared, organized, and effective. Their life is easier, which means your case runs smoother. By now, you've assembled a powerful mosaic of your lawyer's reputation. You know they have a clean disciplinary history. You know if their peers, the experts, consider them to be elite. You've analyzed the patterns in their client reviews to understand what it's actually like to work with them. And you've looked for the subtle but powerful signs of respect from the legal community itself. You have a very, very good idea of the person you're dealing with. But there's still a critical piece missing. A great reputation is built on something real. It's built on experience. It's built on a track record. How do you actually verify their experience? How do you look into their history in the courtroom and see the kinds of cases they've actually handled? We've learned what the experts think of them. Now it's time to look at the evidence. We're going to become legal archaeologists and dig into their actual case history. This is where we separate the talkers from the winners. The first tool in our archaeological kit is the most powerful, and it's called PACER. That's PAR, which stands for Public Access to Court Electronic Records. This is the federal government's official system for all federal appellate, district, and bankruptcy court records. Think of it as the ultimate library of legal battles fought in the highest courts of the land, besides the Supreme Court. If your potential lawyer claims to be a federal litigator, a high-powered corporate attorney, or someone who handles serious white-collar crime, their work product, their history, their wins, and their losses are likely etched into the PACER database. Now, you might think something this powerful is locked away for lawyers only. It's not. It's for you. Anyone can sign up for a PACER account. There is a small fee, about 10 cents per page you access, but it's capped at $3 for most documents, meaning you'll never pay more than that for a single filing, no matter how long it is. And here's a pro tip. The government waives the fees for anyone who accrues less than $30 in charges in a quarter. So for a casual user just researching one or two lawyers, it's effectively free. Once you're in, you can search by a lawyer's name. You type it in, and suddenly you're looking at a list of every single federal case they've been involved in. This is not a summary. This is the real deal. The raw data. But a list of cases is just the beginning of our dig. We need to know what to look for. First, look at the volume and the dates. Is this a lawyer with a steady stream of cases over the last decade? Or did they have a flurry of activity back in 2009 and not much since? A busy, currently active lawyer is a lawyer who is sharp, up to date on the law, and in demand. An empty docket could mean they've shifted their focus, or worse, that they're not the go-to person they claim to be. Next, and this is critically important, look at the nature of the cases. Let's say you need a lawyer for a complex trademark infringement lawsuit for your small business. You look up a lawyer who has a flashy website talking about protecting your brand. You run their name through PACER. You find 50 cases. Impressive, right? But then you start clicking. Case 1, a bankruptcy filing. Case 2, a Social Security disability appeal. Case 3, another bankruptcy. You go through all 50, and not a single one has anything to do with intellectual property. This lawyer isn't a trademark expert. They're a bankruptcy attorney who built a nice website. You just saved yourself tens of thousands of dollars and a world of heartache. You need to match their actual experience to your specific problem. Don't hire a world-class heart surgeon to operate on your brain. But it gets deeper. Once you click into a specific case, you're looking at the docket sheet. This is the minute-by-minute log of everything that has happened in the case. Here you want to find your lawyer's name and look for their role. Are they listed as lead counsel or attorney of record? This means they were in the driver's seat. Or are they one of 10 names listed under of counsel or associate attorney? This might mean they were just carrying the lead lawyer's briefcase. It's a huge difference. You want the person who is calling the shots, not the one taking notes. Now for the real detective work. Reading the documents. You don't need to read every page of a 1,000-page filing. You're looking for the big stuff. Look for motions they filed. A motion for summary judgment, for instance, is a bold move where your lawyer asks the judge to rule in their favor immediately, without a full trial, because the evidence is so overwhelmingly on your side. Did they file one? Did the judge grant it? That's a sign of a confident, efficient lawyer who can win decisively. Or do you see a lot of motions to compel discovery? This can be a good sign. It means the other side is hiding evidence, and your lawyer is aggressively fighting to uncover it. It shows they're a pit bull, not just in their marketing but in the courtroom. What about the outcome? Court dockets don't have a giant win or loss stamp on them. You have to interpret the clues. Look for an order of dismissal. If it says the case is dismissed with prejudice, that's a home run. It means the case is over forever and can't be brought back. If it's dismissed without prejudice, it's less of a total victory. Look for a stipulation of dismissal. This usually means the parties reached a settlement. Don't see this as a weakness. A lawyer who consistently gets favorable settlements for their clients is a master negotiator, who is saving them the immense cost and risk of a trial. That's a massive win. But what if your legal issue isn't a big federal case? What if it's a divorce, a local contract dispute, or a DUI? That's where we have to dig into the state and county court records. This gets a little trickier because every state is different. There's no single unified system like PACER. New York has its e-court system. California has its case search portals for each superior court. Texas has its own network. So how do you find it? It's simple. You go to your favorite search engine and you type your state name court records search or your county name clerk of court records. The first few results will almost always lead you to the official government portal. Many of these are free to search, though some may have small fees similar to PACER to view the actual documents. The process is the same. You're searching the lawyer's name. You're looking for volume, case type, their role, and the outcomes. Does the family lawyer you're considering primarily handle high-asset, contentious divorces, or do they mostly just file paperwork for simple, uncontested ones? There's a world of difference in skill required. Does the criminal defense attorney you're looking at actually take cases to trial, or do they plead out every single one at the first opportunity? Their record will tell the story they might not want to tell you themselves. Imagine you're vetting a personal injury lawyer. You check the county court records. You see they've filed 200 lawsuits in the last 5 years. Good, they're active. You start opening the dockets. You notice a pattern. In almost every case, a lawsuit is filed, and then a few weeks later, there's a stipulation of dismissal. This tells you their entire business model is likely based on sending a scary-looking demand letter, and then taking the first lowball settlement offer the insurance company throws at them. They're a settler, not a fighter. If you have a serious injury and need someone to go to war for you to get the maximum compensation, this is not your lawyer. You just discovered their entire playbook without ever speaking to them. This is the power of digging into the records. You are stripping away the marketing, the fancy suits, and the confident handshakes, and you are looking at the unvarnished truth of their professional life. You're reading their biography as it was written, motion by motion, case by case, in the official record. You're not just hiring a lawyer anymore. You're making an evidence-based decision about who you will trust with your money, your business, your family, or your freedom. We've now checked their license and discipline history. We've seen what their peers think of them. And now we've gone deeper than 99% of clients ever do, by analyzing their actual track record in court. We know what they've done. But there's one more critical piece of the puzzle that can make or break your case before it even begins. The money. How much will this expertise actually cost you? And more importantly, are their billing practices and fee agreements a hidden red flag signaling trouble ahead? The answer is far more complex than just an hourly rate, and it's what we're exposing next. Let's start with the hourly rate, the most common fee structure and, paradoxically, the most dangerous. On the surface, it seems fair. You pay for the lawyer's time. Simple. But the hidden danger lies in the incentive structure. An hourly lawyer is financially incentivized to be inefficient. The longer your problem takes to solve, the more money they make. This isn't to say all hourly lawyers are dragging their feet, but the system itself rewards slowness. And it gets worse when you understand the unit of time they use. The billable hour, typically broken down into 6-minute increments. Think about what that means. You call your lawyer with a quick 2-minute question. On your next bill, you won't see a charge for 2 minutes. You'll see a charge for 6 minutes, or 1/10 of an hour. They send a 1-sentence email reply? That's another 6 minutes. They leave a 30-second voicemail for the opposing counsel? 6 minutes. These tiny slivers of time, these billable units, accumulate at a terrifying rate. A lawyer charging $400 an hour is billing you $40 for that 2-minute phone call, $40 for that quick email. It's a constant, silent drain on your finances, and if you're not demanding detailed, itemized monthly statements, you could be facing a 5-figure bill before you even realize what's happening. This is why you must ask any potential lawyer who works hourly, what is your minimum billing increment? And who, specifically, will be billing on my case? And what are their individual rates? Because you're not just hiring one lawyer. You're often hiring a team. A senior partner might be $600 an hour, a junior associate $300, and a paralegal $150. You need to know if you're being billed $600 for a partner to do work a paralegal could have handled for a fraction of the cost. This isn't about being cheap. It's about being smart. Next up is the flat fee. This is often positioned as the worry-free option. One price, one payment, problem solved. It's common in straightforward cases like an uncontested divorce, a simple bankruptcy, or drafting a will. And it can be a great option providing cost certainty. But the devil is in the details of what that flat fee actually includes. Think of it less like an all-inclusive resort and more like a budget airline ticket. The main flight is covered, but every single extra costs you. The flat fee almost never covers third-party costs, also known as hard costs. These are things like court filing fees, fees to have documents served on the other party, expert witness fees which can run into the thousands, or the cost of a court reporter for a deposition. These are legitimate expenses, but if you're not prepared for them, a $10,000 flat fee can easily balloon into a $15,000 total cost. The critical question here is, can you provide me with a written list of all anticipated hard costs that are not included in the flat fee? You also need to know what happens if the simple case suddenly becomes complicated. If your uncontested divorce suddenly becomes a bitter custody battle, is there a clause that allows the lawyer to switch from a flat fee to a much more expensive hourly rate? You need that defined in writing before you sign anything. Then we have the most famous of them all, the contingency fee. The classic "you don't pay unless we win" model, seen in every personal injury and medical malpractice commercial. Sounds like a risk-free proposition, and it allows people without deep pockets to access the justice system. But the way this fee is calculated can make a monumental difference in how much money actually ends up in your pocket. The standard contingency fee is around 33%, or 1/3 of the recovery. But the crucial multi-thousand-dollar question is, 1/3 of what? Is the lawyer taking their percentage from the gross settlement, the total amount the other side pays? Or are they taking it from the net settlement, the amount left over after all the case expenses have been deducted? Let's run the numbers. Imagine you win a $100,000 settlement. Your case had $10,000 in expenses for expert reports and depositions. If the lawyer calculates their fee on the gross amount, they take $33,000 right off the top. Then the $10,000 in expenses is deducted. You are left with $57,000. But if the agreement states the fee is calculated on the net, the $10,000 in expenses is deducted first, leaving $90,000. The lawyer's 1/3 fee is now calculated on that $90,000, making their fee $29,700. You are left with $60,300. That single sentence in the fee agreement changes your take-home amount by over $3,000. You absolutely must clarify, is your contingency fee calculated on the gross or the net settlement? And get it in writing. Finally, there's the retainer. This is one of the most misunderstood terms in law. A retainer is not a down payment. It is not the lawyer's money. For most individual clients, a retainer is an advance deposit on future fees. Your money is placed into a special trust account, called an IOLTA account. The lawyer cannot touch that money until they have actually earned it by performing work. As they work, they bill against that retainer. So if you pay a $5,000 retainer, and they do $1,000 worth of work in the first month, they will transfer $1,000 from the trust account to their business account and send you an itemized bill showing that your retainer balance is now $4,000. This is a system of trust, and you need to verify. You have the right to receive a regular, monthly, itemized statement showing every single charge, who performed the work, what they did, and how much time it took, down to the 6-minute increment. This is your primary tool for monitoring your case's cost. If a lawyer is hesitant to provide this or sends you a vague, one-line bill that just says, "for services rendered," that is a colossal red flag. It's your money. You have a right to know exactly how it's being spent. All of these fee structures are ultimately governed by one document: the fee agreement, sometimes called a retainer agreement or engagement letter. This is the single most important document defining your relationship with your lawyer. Do not treat it as a formality. Do not just skim it and sign. It is a legally binding contract that dictates the terms of your financial life for the duration of your case. A verbal agreement is worthless. If a lawyer is unwilling to put every single detail of your financial arrangement into a clear written document for you to review, you must walk away. No exceptions. This agreement should be your shield. It must clearly define the scope of representation, what they will do, and just as importantly, what they will not do. It must detail the exact fee structure, the rates of every person working on your case, and a clear policy on how expenses are billed. Some firms, for example, charge you 10 cents per photocopy, while others might charge $1. Some bill you for postage, others don't. These seem like minor details, but over the life of a complex case, they can add up to thousands of dollars. Be on high alert for the red flags. Vagueness is your enemy. If a lawyer says things like, "Don't worry about the details, we'll sort it out," or "Our fees are pretty standard," that's a signal to run. High-pressure sales tactics are another. A good lawyer will want you to be a fully informed client. They will encourage you to take the fee agreement home, read it carefully, and ask questions. Anyone who pressures you to sign on the spot is more interested in your wallet than your welfare. I once spoke to a small business owner who learned this the hard way. He hired a lawyer for a contract dispute. They had a quick conversation, a handshake, and a verbal agreement on an hourly rate. The business owner, busy running his company, just trusted the lawyer to handle it. 6 months went by with only a few brief update calls. Then an envelope arrived. Inside was a single-page invoice with one line: "For professional services rendered, $47,500. There was no breakdown, no list of tasks, no accounting of hours. It was a financial gut punch. Because he had nothing in writing, he was facing a nightmare, he said. She said, battle over the bill. All while trying to deal with his original legal problem. A clear, written fee agreement would have prevented all of it. Now you know how to protect your wallet. But a cheap lawyer who loses is the most expensive lawyer of all. So how do you dig into their actual courtroom record? How do you find out if they win? Or if they just know how to bill? That requires looking beyond their own marketing and into the public record. And it's a step most people miss. Let's start with the most powerful tool at your disposal, and the one that is most often overlooked: the court docket. Every lawsuit, every felony charge, every bankruptcy filing in the United States creates a public record. This isn't a summary or a press release. It's the raw, unfiltered log of the legal system in action. Think of it as the black box flight recorder for a lawyer's career. Their website tells you the story they want you to hear. The court docket tells you the story that actually happened. Now I have to be honest with you. This isn't always easy. Accessing these records isn't like a simple Google search. The systems are fragmented, often clunky, and sometimes hidden behind paywalls or registration forms. This is by design. It creates a barrier that keeps most people out. But you're not most people. You're here to learn how to break through that barrier. First, you need to understand that the U.S. has two major, parallel court systems: federal and state. A lawyer might practice in one, the other, or both. You need to check both. Let's start with the federal system. This is where you'll find cases involving federal laws, things like bankruptcy, major interstate fraud, civil rights violations, or lawsuits against the U.S. government. The federal government has a centralized system for this called PACER, which stands for Public Access to Court Electronic Records. This is your skeleton key to the entire federal judiciary. You'll need to create an account on the PACER website. Yes, there's a small fee for accessing documents, typically 10 cents per page. But hear me out. Spending $5 or $10 to vet a lawyer you're about to pay tens of thousands of dollars is one of the highest return investments you will ever make. Think of it as the price of admission to the truth. Once you're in, you can search by a lawyer's name or their law firm's name across all federal district and bankruptcy courts. What you're looking for is the docket sheet for their cases. This is a chronological list of every single thing that has happened in a case. Every motion filed, every judge's order, every deadline. You don't need to be a legal scholar to understand it. You're looking for clues. Is this lawyer constantly filing motions and fighting for their client? Or are they passive, letting the other side dictate the pace? You can see if they're frequently asking the court for extensions, which might suggest they're disorganized or overloaded. You can see the final disposition of the case, Was it a judgment in their client's favor? A settlement? A dismissal? A guilty plea? Pacer gives you the ground truth, stripped of all the marketing spin. Now for the more complicated part, the state courts. This is where the vast majority of cases happen: personal injury, divorce, contract disputes, DUIs, and most criminal matters. And unlike the federal system, there is no single unified state pacer. Each state has its own system. And to make it even more fun, sometimes each county within a state has its own separate online portal. It's a messy, confusing patchwork, and it's where most people give up. But here's the strategy. Start by identifying the primary counties where your lawyer practices. If their office is in Chicago, you'll start with the Cook County Circuit Court. If they're in Miami, you'll search the Miami-Dade County Clerk of Courts. Your search query should be something like County Name Court Records Search or City Name Court Case Lookup. This will usually lead you to an online portal run by the county clerk. Many of these portals are free to search, though some may charge for downloading documents, similar to Pacer. Be prepared for a user experience straight out of 1999. These sites are often old, not mobile-friendly, and require precise information. You'll likely need the lawyer's full name. If it's a common name like John Smith, you might need their state bar number, which you found in the previous step, to narrow down the results. Once you're in and you've found your lawyer, don't just look at one or two cases. You're looking for patterns. This is like being a detective, piecing together a profile from scattered evidence. Here's what you need to analyze. First, volume and type. Does the lawyer's actual caseload match their advertising? If they market themselves as a highly experienced trial attorney for complex business litigation, but their record shows nothing but 100 minor landlord-tenant disputes, that's a massive red flag. It tells you their real experience doesn't match their marketing persona. What's the volume of cases? A lawyer with very few cases might be new, or they might be highly selective, giving immense personal attention to each client. A lawyer with thousands of cases might be a well-oiled machine, or they might be running a settlement mill, an operation that churns through cases quickly, often accepting lowball offers just to close the file and move on. Second, look at their role. Are they listed as the lead attorney on the case, or is their name just one of several from a large firm? This tells you how much responsibility they actually had. Are they the one arguing in court, or are they just carrying the senior partner's briefcase? Third, and most critically, you need to look at the outcomes. This is where you separate the talkers from the winners. Look for keywords in the case disposition: judgment for plaintiff or judgment for defendant. If your lawyer represents plaintiffs in injury cases, you want to see a lot of judgment for plaintiff or settlement. If you're hiring a criminal defense lawyer, you're not necessarily looking for not guilty verdicts, as those are incredibly rare. Instead, you're looking for evidence of a fight. Did they file a motion to suppress evidence? Did they get charges reduced from a felony to a misdemeanor? A record showing a long series of clients pleading guilty to the maximum initial charge is a sign of a lawyer who just processes paperwork, not one who advocates. Conversely, a string of cases listed as dismissed for want of prosecution could be a red flag, suggesting they weren't actively working on the case, forcing the court to throw it out. Dismissed with prejudice means the case is permanently over and can't be refiled, which is a devastating loss for their client. But you have to interpret this with intelligence and nuance. Most civil cases, over 95% of them, end in a settlement, not a trial. A lawyer with a long list of settled cases isn't weak. They may be a brilliant negotiator who consistently gets great results for their clients without the time, expense, and risk of a full-blown trial. The public record won't tell you the settlement amount, but it will tell you that the lawyer was able to bring the case to a final, agreed-upon conclusion. Ultimately, you are not looking for a single data point. You are looking for a trend. One bad outcome is an anomaly. A dozen bad outcomes is a business model. By digging into federal and state court records, you move beyond the curated testimonials and 5-star reviews. You are accessing the raw data of their professional life, seeing not what they claim to do, but what they have actually done. This single step, this willingness to navigate the clunky websites and decipher the legal jargon, is what separates a hopeful client from an empowered one. It gives you an unshakable foundation of facts upon which to build your decision. But a lawyer's performance isn't just measured in wins and losses filed with the clerk. It's also measured in the hallways of the courthouse, in the conference rooms during negotiations, and in the minds of the people they go up against. What do other lawyers say about them when they think no one is listening? What is their reputation among the judges who have seen them in action? That paper trail is only half the story. To get the other half, you need to learn how to tap into the legal community's invisible network. And this invisible network, it's not some secret society. It's the simple day-to-day ecosystem of the legal world. It's the court clerks who see 100 lawyers a week, the opposing attorneys who have gone to war with your candidate, and the paralegals who know exactly how the sausage gets made behind the firm's polished mahogany doors. These people hold the keys to understanding a lawyer's true character, competence, and temperament. Your job is to politely ask for the right key. Let's start with the gold standard. Other lawyers. Specifically, lawyers who have been on the other side of a case from your target attorney. Think about that for a second. Who knows your potential lawyer's strengths and weaknesses better than someone whose entire job was to exploit those weaknesses and overcome those strengths? Finding them is easier than you think. Using the court records we talked about earlier, pull up a few of your lawyer's past cases. The documents will list the attorney of record for the opposing side. That's your target. Now this takes guts, but the payoff is immense. You call their office. You'll likely get a secretary or a paralegal. Be concise and incredibly respectful. Say something like, "My name is your name, and I'm a member of the public doing due diligence on hiring an attorney. I saw that your firm was opposing counsel to attorney Jane Smith in the Miller versus Thompson case a few years back. I know you're busy, but I was hoping to ask the handling attorney just 1 or 2 quick questions about their professionalism, if they have a moment." The key here is framing. You are not asking them to betray confidences or talk trash. You are asking for a professional assessment. When you get the lawyer on the phone, be direct. "I'm considering hiring Jane Smith for a matter similar to the Miller case. From your perspective as opposing counsel, was she prepared? Was she professional to deal with? Was she an ethical advocate for her client?" And then the killer question. "All things considered, if you were in my shoes, is she someone you would hire?" Listen carefully to the answer. A genuinely respected lawyer will get a glowing review, even from a former adversary. You'll hear things like, "Look, she was tough as nails, and I didn't enjoy being on the other side, but she is brilliant, and her client was lucky to have her." That is a 10-ton green flag. But if you hear a long pause followed by carefully chosen diplomatic words like, "Well, she certainly has a unique style," or "we had a spirited litigation," that's your red flag. Lawyers are masters of language. They know how to tell you everything by saying almost nothing at all. What they don't say is often the most important part of the conversation. Another brilliant tactic is to call a different highly rated lawyer in the same practice area and city. Pose a hypothetical. "Hi, I'm looking for a top-tier family law attorney for a complex divorce. I know you're one of the best, but if for some reason you weren't available, who would be on your short list of 2 or 3 lawyers you trust with a family member's case?" If your target lawyer's name is on that list, you've struck gold. If the expert you called has never heard of them or pointedly does not mention them, that silence speaks volumes. Next, let's talk about the unsung gatekeepers of the legal universe. Court clerks, judicial assistants, and courthouse staff. These people are the system's institutional memory. They see it all. They see the lawyer who shows up late and disheveled, begging for an extension because he forgot to file a motion. They see the lawyer who treats the staff with contempt. And they see the lawyer who is always prepared, always polite, whose filings are immaculate, and who is respected by everyone from the bailiff to the judge. You can't just walk up to a clerk and ask, "So what's the deal with Attorney Smith?" You'll be met with a stone wall. The approach must be one of subtlety and respect. The next time you're at the courthouse looking up records, find a moment when the clerk isn't swamped. Be friendly. Ask for their help with a file and thank them profusely. Then you can try a casual observational question. "Wow, you all are so busy. I've been looking through these cases and I see Attorney Smith's name everywhere. He must practically live here." And then you listen. The clerk might give you a tired smile and say, "Oh yes, we know Mr. Smith very well." Pay attention to the tone. Is it a fond, respectful tone? Or is it the kind of weary tone you'd use to describe a recurring problem? You could follow up with, "He seems to have a reputation for being very thorough." A clerk who respects the lawyer might say, "Absolutely. His filings are always perfect, which makes our job so much easier." A clerk who doesn't might just give a non-committal "uh-huh" and turn back to their work. An eye roll, a sigh, a quick glance to a coworker. These nonverbal cues are pure, unfiltered data. Now for the deepest level of intelligence, former employees. A lawyer's current staff is bound by loyalty, and a paycheck. But someone who left the firm 6 months or a year ago, they are a potential goldmine of information about the firm's internal chaos, billing practices, and the lawyer's actual personality. LinkedIn is your primary tool here. Search for the law firm, then look at the profiles of people who list it under past experience. Look for former paralegals, legal assistants, or associate attorneys. Reaching out requires tact. Send a connection request with a note. Hi name. I'm currently considering retaining law firm name, and saw you used to work there as a paralegal. I'm trying to get a feel for their approach with clients. Would you be open to a very brief chat about your general experience at the firm? Many will ignore you, but some, especially if they left on bad terms, will be more than happy to share their story. When you speak to them, ask about the process, not just the person. How did the firm handle client communication? Were clients kept up to date? What was the general level of organization on cases? Was it proactive or always putting out fires? Was the lead attorney generally accessible to the staff and the clients? These questions get to the heart of competence and client service without making it feel like a personal attack. A former employee can tell you if the lawyer you're considering is a brilliant legal mind who is an organizational disaster, or a smooth talker who leaves all the real work to an overwhelmed junior associate. That's information you will never ever find on a website. Putting it all together, you're not looking for a single piece of gossip. You are a detective building a case profile. You're looking for patterns. If one opposing lawyer says your guy is a hothead, it could just be a personality clash. But if you hear from an opposing lawyer, a former paralegal, and a court clerk that the attorney is arrogant, unprepared, and difficult to work with, you have a verified, multi-source consensus. You have the truth. The paper trail tells you what a lawyer has done. This human network tells you who they are. You've checked the official records. You've tapped into the invisible network. You know what the state bar thinks of them, and you know what their peers think of them. But there's one more source, one that is often the most powerful and overlooked of all. The lawyer's own work. Their actual, tangible skill on display. What if you could read the arguments they've made in court? Analyze the quality of their legal writing? See for yourself if they are a sharp, persuasive advocate or just a mediocre paper pusher. You can. And it's all waiting for you, filed away in public records if you just know how to look. The first place to look, the master key that unlocks the entire federal court system, is a government website called PACER. That's PAR, which stands for Public Access to Court Electronic Records. Think of it as the Google for every lawsuit filed in a United States District Court, Bankruptcy Court, or Court of Appeals. If your lawyer has ever handled a federal case, whether it's a major corporate dispute, a bankruptcy, or a federal criminal charge, the paperwork is likely on PACER. Now, getting access isn't like signing up for Netflix. This is a government system, so it's a bit clunky. You'll need to register for an account on the PACER website. They'll ask for your personal information and a credit card. And yes, a credit card, because PACER isn't entirely free. They charge a small fee, currently 10 cents per page, to view or download documents. But here's the critical pro tip they don't advertise on the homepage. If your usage doesn't exceed $30 in a quarterly billing cycle, that's 300 pages of documents, the fees for that quarter are waived. So for the average person doing a background check on 1 or 2 lawyers, it's effectively free, as long as you're strategic about what you download. Once you're in, you'll use the PACER Case Locator. This is your search engine. The most effective way to start is by searching the lawyer's name in the attorney field. Don't just search for John Smith. Search for John Smith and the state where he practices. This will pull up a list of cases where he was listed as an attorney of record. You'll see case numbers, the names of the parties involved, the date filed, and the court where it was held. This list alone is a goldmine. Is this lawyer primarily handling personal bankruptcy cases? Or are they involved in complex, multi-million-dollar patent litigation? The case list gives you an immediate snapshot of their practice area and the scale of their work. But we're not just looking at the menu. We want to taste the food. Click into a few of those case dockets. The docket sheet is the table of contents for the entire lawsuit. It's a chronological list of every single document filed in the case, from the initial complaint to the final judgment. Each entry is a link to the actual document. This is where you put on your detective hat. Now, that's the federal system, centralized and relatively straightforward. But what about state courts, where the vast majority of legal disputes happen? Divorces, personal injury claims, contract disputes, most criminal cases, that's all state level. And this, my friends, is where the real treasure hunt begins, because there is no national pacer for state courts. Each state, and often each county within that state, has its own system. Your strategy here is to start local. Go to Google and search for the clerk of court for the county where your lawyer primarily practices. For example, Los Angeles County Superior Court Case Search or Cook County Circuit Court Docket. Most metropolitan areas will have a searchable online portal. Some are free and user-friendly. Others look like they were designed in 1995 and may require you to set up an account or even pay a subscription fee. Don't be discouraged. The information is public. Their websites are just the gatekeepers. If you can't find what you need online, you can always do it the old-fashioned way. Go down to the courthouse. The clerk's office will have public access terminals where you can search for cases and view documents, often for free. You can request physical copies of files, though you'll have to pay for the photocopies. Okay, so whether you're on Pacer or a clunky county website, you've found a list of cases. You've pulled up the docket sheet. Now what? You can't read 1,000 pages of legal filings. You need to know what to look for. You're looking for the pivotal moments in the case that reveal the lawyer's skill, strategy, and professionalism. First, find the initial complaint or petition. This is the document that kicked off the lawsuit. Read the first few pages. Is it written in clear, persuasive language? Does it tell a compelling story about why their client deserves to win? Or is it a sloppy boilerplate document filled with typos and vague accusations? The complaint is the first impression a lawyer makes on the judge. A top-tier lawyer crafts it like a work of art. Next, scroll through the docket looking for major motions. Don't worry about the routine scheduling orders. Look for titles like Motion to Dismiss or Motion for Summary Judgment. These are the heavyweight bouts of a lawsuit. A motion to dismiss is an attempt to get the case thrown out at the very beginning. Did your lawyer file one? More importantly, did they win? Read the judge's order. The order will explicitly state whether the motion was granted or denied, and will often explain the judge's reasoning. It's a direct report card on the strength of your lawyer's argument. If you see a pattern of your potential lawyer getting their cases dismissed early on, that's a massive red flag. The holy grail is the motion for summary judgment. This is where a lawyer argues to the judge, "Your Honor, the undisputed facts are so overwhelmingly in our favor that we don't even need a trial. You can rule for us right now." These motions are incredibly detailed. They are packed with evidence. Excerpts from depositions, affidavits, expert reports, emails, contracts. Reading one of these is like reading the lawyer's entire game plan. It showcases their ability to weave together facts and law into an unstoppable narrative. Is the motion they filed a masterpiece of logic and persuasion? Or is the one filed against them a devastating takedown that they couldn't answer? The documents are right there. You can read both sides and decide for yourself. Pay close attention to discovery disputes. Discovery is the process where both sides exchange evidence. If you see a lot of entries like motion to compel, that means one side is refusing to hand over information. If your potential lawyer is constantly being hit with motions to compel, it could suggest they are disorganized, uncooperative, or even trying to hide unfavorable evidence. On the other hand, if they are the ones aggressively filing these motions and winning them, it shows they are a fighter who will leave no stone unturned for their client. Finally, look for the outcome. Did the case go to a jury trial? If so, what was the verdict? Did it settle? The docket might say stipulation of dismissal, which usually means a settlement was reached. You won't know the terms of the settlement, but you can see at what stage it happened. Did the lawyer fight tooth and nail through years of litigation to get a good settlement on the eve of trial? Or did they fold early at the first sign of trouble? You are not just looking at wins and losses. You are looking for patterns of behavior and assessing the quality of their work product. Are their filings consistently well written and on time? Do judges seem to respect their arguments in their written orders? Do they seem to be driving the strategy in their cases, or are they always reacting to the other side's moves? Each document you pull from the court file is a piece of a puzzle, and when you put them together, you get a picture of the kind of advocate you are thinking of hiring, not the one from the billboard or the slick TV commercial, but the one who actually shows up and fights in the courtroom. This is the real due diligence. This is how you separate the sharks from the minnows. So you've seen them in their natural habitat, the courtroom, but what you witnessed was the final performance. It was the culmination of weeks, maybe months of behind-the-scenes work. Now, we're going to pull back the curtain and examine the engine that drives that performance. We're going to look at the evidence of their intellect, their reputation among their peers, and the very DNA of their legal work. This is where we move from observation to investigation. First, let's talk about a lawyer's mind. How do you get inside it? How do you know if they are a genuine expert or just someone who is good at memorizing a script? You look for their intellectual footprint online. I'm not talking about their Yelp reviews or their perfectly curated website testimonials. I'm talking about the raw output of their brain. Does this lawyer write? Do they publish articles in legal journals? Do they maintain a blog that actually dissects complex legal issues, rather than just posting generic advice like don't drink and drive? A lawyer who takes the time to write and publish is showing you several critical things. First, they have a deep enough understanding of their field to be able to teach it. Second, they have a passion for it that extends beyond the billable hour. And third, they are confident enough in their own expertise to put it out there for public scrutiny by their peers. Find these articles. Read them. You don't need a law degree to understand if the writing is clear, logical, and insightful. Are they just summarizing a new statute? Or are they providing a sharp, critical analysis of its potential impact? You are test driving their analytical skills before you ever sign a retainer. Even more powerful is finding out if they teach other lawyers. This is the gold standard. In the legal world, this is done through something called CLEs, or continuing legal education. Every lawyer is required to take these courses to keep their license. But who teaches them? The experts. The lawyers that other lawyers look up to. Search for your potential lawyer's name plus the term CLE presentation or legal seminar. If you find them listed as a speaker or panelist for a state bar association or a trial lawyers college, that is a massive green flag. It's the equivalent of finding out the chef you're considering hiring for your wedding also teaches at the Culinary Institute of America. It tells you they are not just a practitioner, they are a master of the craft. Sometimes the course materials or even a video of the presentation is available online. This is an absolute treasure trove, giving you a direct window into how they deconstruct problems and communicate solutions. This same principle applies to their professional social media. Forget their firm's Facebook page with its holiday greetings. Look for their personal LinkedIn or Twitter profile. What are they sharing? What conversations are they a part of? A top-tier lawyer will often engage in high-level discussions with other attorneys, reporters, and legal scholars. They'll be dissecting recent Supreme Court rulings or debating the nuances of a new piece of legislation. This is their mind at work in real time. Contrast that with a lawyer whose feed is just a series of ads for their own firm. One is contributing to the legal conversation, the other is just shouting into the void. You want the contributor. You want the one who is so immersed in the world of law that they live and breathe it, even online. Now let's move from the digital world to the real one. We're going to tap into the most powerful and closely guarded source of information in the entire legal community: the Whisper Network. Every town, every city has one. It's the invisible web of knowledge that lawyers, judges, and courthouse staff use to understand who's who. It's where reputations are truly made and lost, far from the public eye, and you can access it. Here's how. Let's say you need to hire a top-notch divorce attorney. You have a name, let's call her Jane Smith. Don't just call other divorce attorneys to ask about her. They're her direct competitors and might not give you a straight answer. Instead, you're going to triangulate. Make a list of 3 highly respected lawyers in your town who practice in completely different fields: a corporate lawyer, a criminal defense attorney, and a real estate lawyer. You're going to call them. When you get them on the phone, you say something like this: "Hi, my name is..." Your name. "I have a quick question and I was hoping you could point me in the right direction. I have a very serious family law matter, and I'm considering hiring an attorney named Jane Smith. I see that your firm has an excellent reputation in their field of law, and I deeply respect that. In your opinion, as a fellow member of the legal community here, what is Jane Smith's reputation? Is she someone you would trust to handle a case for a member of your own family?" The effect of this question is profound. You've complimented them. You've acknowledged their expertise. You've made it clear you're not a potential client wasting their time. And you've framed the question in personal, ethical terms: a member of your own family. Lawyers talk. They know who the sharks are, who the lazy ones are, who the brilliant strategists are, and who the blowhards are. Because they aren't competing with Jane Smith for clients, they have very little reason to be dishonest. Listen carefully to their response. A long pause is a bad sign. Vague praise like, "Oh yeah, I've heard of her," is a bad sign. But if they say, "Jane is a killer. She's tough but fair, and I would be terrified to go up against her," you've just struck gold. They might even say, "Jane is good. But the person you really want for a case like yours is John Doe. They've just given you an even better lead, a referral from one expert to another. This is the single most powerful technique for vetting a lawyer, period. It's getting a chef's recommendation for another restaurant. The next layer of the Whisper network is more delicate. Courthouse staff. The clerks, the judicial assistants, the bailiffs. These are the people who see it all. They see the lawyers who are always late, the ones who file sloppy paperwork, the ones who are disrespectful to the judge's staff, a cardinal sin. And they see the ones who are prepared, professional, respected, and who run their practice like a well-oiled machine. You can't just walk up and interrogate a court clerk, but you can be polite, be observant, and listen. When you're at the courthouse looking up those case files we talked about, be friendly. You might say to the clerk, "I'm trying to learn more about how the family court works. I've seen Attorney Smith's name on a lot of cases. She seems to be in here quite a bit." And then just stop talking. The clerk's reaction will tell you everything. A simple, "Yep, she is," with a warm smile is a good sign. A sigh, an eye roll, or a terse "next" tells you all you need to know. They are the gatekeepers of the court's institutional knowledge, and their nonverbal cues are often more honest than 1,000 online reviews. Finally, we need to go one level deeper on those public court records. It's not enough to just see if they won or lost. You need to look at the quality of the work itself. This is like a mechanic not just looking at a car's paint job, but opening the hood and inspecting the engine. In the legal world, the engine is called motion practice. Motions are the formal written requests that lawyers make to a judge throughout a case. A motion to dismiss the case, a motion to compel the other side to turn over evidence, a motion for summary judgment. These documents are often public record. Get your hands on a few motions filed by your potential lawyer. Again, you don't need to be a lawyer to evaluate them. Is the document clean, well formatted, and free of typos? A sloppy document suggests a sloppy mind and a sloppy practice. Is the argument clear and easy to follow? Or is it a rambling, confusing mess of legal jargon? Great lawyers are great communicators, especially in their writing. They can take a complex set of facts and legal principles and weave them into a simple, powerful, and persuasive story for the judge. Read a motion from your potential lawyer, and then, if possible, read the opposing counsel's response. Whose argument is more compelling to you, a layperson? Whose story makes more sense? Often, the quality of the legal work is glaringly obvious, even to an untrained eye. You are looking for craftsmanship. You are looking for signs of a sharp, organized, and persuasive mind, because the document you are holding is the exact same quality of work they will be doing for you. It's a direct preview of the service you're about to pay a fortune for. Don't you want to see it first? Yes, you absolutely want to see it first. And that preview extends far beyond the four corners of a legal document. You need to see the lawyer in the wild. You need to understand their reputation not just on paper, but in the real world. And in the digital world, where whispers become shouts and a person's true character is revealed. This is where we move from analyzing their work to analyzing their world. Let's start with the most obvious, and often most misleading source of information: client reviews. You'll find them on Google, Yelp, Avu, FindLaw, and a dozen other sites. Most people scan the star rating and move on. That is a colossal mistake. In fact, a lawyer with a perfect 5.0 star rating across the board can sometimes be a bigger red flag than one with a 4.7. It can suggest they're aggressively curating reviews, or worse, that they don't have enough clients to have run into the inevitable difficult situation. Here's the secret the pros know. You don't read reviews to find out if the lawyer is good. You read them to find out how they are bad. You are hunting for patterns. A single one-star review from a disgruntled client who clearly had unrealistic expectations is just noise. But 5 one-star reviews all screaming about the same exact thing? That's not noise. That's a fire alarm. Ignore the emotional language. Ignore the drama. Look for the data. Are multiple, separate people over a period of months or years all saying the same thing? The lawyer never called me back. I only ever spoke to their paralegal. They billed me for things we never discussed. They were completely unprepared for our meeting. When you see the same specific complaint echoed by different voices, you are no longer reading an opinion. You are looking at a business practice. You are seeing a preview of how you will be treated when the ink is dry on your retainer agreement. But the real gold isn't just in the review itself. It's in the lawyer's response. A lawyer's reply to a negative review is one of the most honest, unfiltered windows you will ever get into their soul. Do they respond with a calm, professional, and empathetic tone? even if the client is being unreasonable? Something like, "We're sorry you had this experience. Client communication is our top priority, and it appears we fell short here. While we cannot discuss the specifics of your case publicly due to confidentiality, we urge you to contact our office directly so we can resolve this." That shows class. That shows emotional control. That shows a focus on solutions, not ego. Or, do they go on the attack? Do they write a multi-paragraph screed calling the client a liar, revealing borderline confidential details to prove their point, and blaming everyone but themselves? I once saw a lawyer respond to a bad review by saying, "This client was impossible to please and refused to take my advice, which is why they lost their case." Think about that. This lawyer, a so-called professional, just threw their own client under the bus in a public forum to save their own ego. Is that the person you want holding your future in their hands? The one who, when things get tough, will point the finger at you? Their response is a live-fire stress test of their professionalism, and you get to watch it for free. Now let's leave the court of public opinion and enter the court of their peers. This is where the amateurs stop their research, but where you will push forward. What do other lawyers, the people who go to battle against them, the judges who preside over their cases, the colleagues who see them when the clients aren't around, what do they really think? This isn't just gossip. This is a structured system of peer review, and it's one of the most powerful vetting tools you have. The gold standard here is a rating from a company called Martindale-Hubbell. For over a century, they have been conducting confidential surveys of lawyers and judges to rate the abilities of other lawyers. Their highest rating is AV Preeminent. This isn't some marketing gimmick you can buy. It's earned. The S signifies the highest level of legal ability, and the V stands for very high ethical standards. To get this rating, a lawyer has to be reviewed by a significant number of their peers, including the lawyers they've opposed in court. Think about that. For a lawyer to get an AV Preeminent rating, even the people they've beaten have to secretly admit, yeah, they're brilliant and they fight fair. A lawyer with this rating has a proven track record of being respected by the very people whose job it is to defeat them. That speaks volumes. Another powerful indicator is being listed as a super lawyer, or in Best Lawyers in America. These aren't just vanity plates either. The selection process for super lawyers, for example, involves a statewide survey of lawyers, independent research into 12 different indicators of peer recognition and professional achievement, and a blue ribbon panel review. Only 5% of attorneys in a state are selected to the super lawyers list. It's a signal that they aren't just competent. They are considered a leader in their field by the people who know the field best. If your lawyer has these kinds of peer-reviewed accolades, it tells you their skill isn't just a marketing pitch. It's been verified under fire by a jury of their toughest critics, their own colleagues. Finally, we come to the most unfiltered, raw, and potentially revealing piece of the puzzle: the lawyer's own voice when they think no one important is listening. I'm talking about their digital footprint. Their website is the curated museum exhibit. Their social media, their blog posts, their comments on articles. That is the messy, chaotic artist studio where the real personality is on display. Start with LinkedIn. Is their profile professional and up-to-date? Do they post insightful articles about their area of law? Or do they just share generic motivational quotes? Do they engage in thoughtful discussions? Or do they get into petty arguments in the comments section? LinkedIn is their professional face to the world. If it's sloppy or unprofessional, that's a data point. Then cautiously look at other platforms like Twitter or a public Facebook profile. This isn't about canceling someone for having a political opinion you disagree with. This is a cold, hard risk assessment of their judgment and temperament. Are they constantly engaged in angry, emotionally charged tirades? Do they pick fights with strangers? Do they exhibit a lack of impulse control? Imagine you're in a delicate negotiation. You need your lawyer to be calm, strategic, and rational. But if their Twitter feed is a non-stop stream of rage and personal attacks, you have to ask yourself, is this the person I want representing my interests when the pressure is on? Will they be able to separate their personal emotions from my legal strategy? The lawyer who spends their evenings screaming at strangers online is likely the same lawyer who will let their ego get in the way of securing you a good deal. Their lack of judgment in public is a preview of their potential lack of judgment in private, when your money and your freedom are on the line. Look for what they write. Have they published articles in legal journals or on industry websites? This demonstrates a desire to be a thought leader and a willingness to put their ideas out there for public scrutiny. It shows they're engaged and passionate about their craft. Conversely, a complete lack of any online presence beyond a basic, 10-year-old website can be a sign of someone who isn't keeping up with the modern world, which may impact how they handle modern legal challenges. You've now analyzed their work, listened to their clients, consulted their peers, and audited their public persona. You've built a multidimensional profile that goes infinitely deeper than a simple license check. You're no longer just hiring a lawyer. You're vetting a strategic partner. But there's one final, crucial battleground where a lawyer's true skill is tested, and it's a place most clients never think to look until it's too late. This final battleground is the court docket. Not the one we looked at before just to see wins and losses. We're going deeper. We are going to read the lawyer's actual work. We are going to analyze the motions they file, the arguments they craft, the very words they use to fight for their clients when no one is watching. This is the paper trail of a warrior, and it tells you more about their competence than any 5-star review ever could. Because in the world of law, the war is often won or lost not with a thundering speech in a packed courtroom, but with a brilliantly written motion, filed silently, electronically, in the dead of night. Think about it. A case can be completely upended by a single document. A motion to dismiss can end a lawsuit before it even begins. A motion for summary judgment can secure a victory without the cost and trauma of a trial. A motion to suppress evidence can cripple the prosecution's entire case. These documents are the legal equivalent of surgical strikes, and the quality of that surgery is on public display for anyone who knows where to look. Most people just hire a lawyer and hope they're a good writer. You are going to know. Let me tell you a story about two small business owners, Sarah and Mark. Both were facing nearly identical, bet-the-company lawsuits from a disgruntled former partner. Both needed a great litigator and fast. Sarah did what most people do. She found a lawyer, let's call him Lawyer A, with a slick website, a dozen glowing testimonials, and a confident, expensive suit. He talked a great game in the consultation. He was aggressive, he was sharp, and he promised to fight tooth and nail. Sarah hired him on the spot. Mark, on the other hand, had been following a process much like this one. He found a potential lawyer, Lawyer B, who was less flashy. Her website was simple. She was quieter, more methodical in her consultation. But before Mark signed anything, he took one final step. He spent a Saturday afternoon and $20 on Pacer, the federal court's online record system, and a few more dollars on his state's online docket. He wasn't looking for wins or losses. He was looking for Lawyer B's work. He found two recent cases she handled that were similar to his. He downloaded a motion to dismiss she had filed in one, and a motion for summary judgment in the other. He wasn't a lawyer, but he didn't need to be. The documents were clean. The arguments were laid out in a logical, step-by-step progression that even he could follow. Every assertion was backed up by a citation to a law or another case. There were no typos. The tone was firm, respectful, and devastatingly precise. It was the work of a craftsman. Mark hired her. Now here's where the paths diverge. 2 weeks into Sarah's case, Lawyer A filed his response to the lawsuit. It was a sloppy, generic, cut-and-paste job. It was filled with what lawyers call boilerplate language, standard phrases that showed little thought or customization to Sarah's specific situation. The opposing counsel, an experienced and ruthless attorney, saw this filing and practically smelled blood in the water. He knew he was up against a lazy, corner-cutting opponent. He immediately went on the attack, filing a dozen burdensome discovery requests, scheduling endless depositions, and burying Sarah and her lawyer in paperwork. He knew Lawyer A wouldn't have the discipline or the skill to fight back effectively on paper. The case dragged on for 18 months. Sarah's legal bills ballooned to over $100,000. The stress nearly destroyed her business. She was constantly on the defensive, reacting to the other side's moves, her lawyer always one step behind. Meanwhile, in Mark's case, Lawyer B went to work. She spent 2 weeks in deep research, poring over every document. Then she produced a masterpiece, a 25-page motion to dismiss. It was a work of art. It systematically dismantled the plaintiff's case, point by point, with surgical precision and overwhelming legal authority. When the opposing counsel received that motion, he didn't see an easy mark. He saw a shark. He saw a lawyer who was not only prepared to fight, but who had already mapped out the entire war. He knew that every step of this litigation would be a brutal uphill battle against a superior strategist. He called his client and said, "We need to talk about settling now." Mark's case was over in 60 days. He settled for a tiny fraction of what he stood to lose, and his legal bills were less than a quarter of Sarah's. The same lawsuit, two vastly different outcomes. Why? Because Mark vetted the one thing that truly mattered: the lawyer's core competency. He looked at the silent battlefield of the court docket. So how do you do this? How do you read the tea leaves of a legal filing? First, you need to find them. For federal cases, things like bankruptcy, major interstate commerce, or lawsuits against the U.S. government, you use PACER. That's PAR, which stands for Public Access to Court Electronic Records. You can create an account online. It costs a few cents per page to view documents, but they cap the cost per document so you won't break the bank. It's the best $20 you will ever spend on legal research. For state-level cases, which includes most divorces, contract disputes, personal injuries, and criminal matters, it's a bit more fragmented. You'll need to search for the online court docket, or case search, for the specific county or state where the lawyer practices. For example, you might search Los Angeles County Superior Court Case Search, or Florida e-filing portal. Most major metropolitan areas have these systems. If you're in a more rural area, or if the records aren't online, you can always do it the old-fashioned way. Go to the county courthouse and ask the clerk for help. It's public information. Once you have the lawyer's name, search for them as an attorney on a case. Pull up a few of their recent cases, ideally ones that are similar to yours. Look for substantive documents. Don't just pull the notice of appearance. You want the heavy artillery: a complaint, a motion to dismiss, a motion for summary judgment, or an appellate brief. Now, what are you looking for? You are not trying to become a legal scholar. You are looking for signs of quality and competence, which are often universal. Number 1, professionalism. Is the document clean? Is it formatted properly? Is it riddled with typos and grammatical errors? If a lawyer can't be bothered to proofread a document that will be read by a judge and opposing counsel, what level of care do you think they're going to give your case? It's a massive red flag that signals sloppiness and a lack of attention to detail. Fatal flaws in the legal profession. Number 2, clarity of thought. Even if you don't understand the specific legal citations, can you follow the argument? Does it flow logically from point A to point B to point C? Or is it a confusing, rambling mess? Great lawyers are great communicators, and that starts with their writing. They make complex ideas simple. A confusing argument on paper is a losing argument in court. Number 3, effort. Does the motion look like it was written specifically for this case with facts and details unique to the situation? Or does it feel like a generic template they just changed the names on? Look at the details. A high-quality lawyer tailors their arguments like a bespoke suit. A lazy lawyer sells you something off the rack and hopes it fits. The other side can always tell the difference. Number 4, tone. How do they write? Are they aggressive and bombastic? Or are they calm, confident, and professional? There's no single right answer here. It depends on what your case needs. But the writing should project confidence and command of the facts, not insecure bluster. By spending just a few hours reviewing a lawyer's actual work, you are piercing the veil. You are moving beyond the marketing, the reviews, the sales pitch, and you are looking at the raw, unvarnished evidence of their skill. You are making a decision based on data, not just a gut feeling. And with that, our journey is complete. We have traveled from the simplest Google search to the most sophisticated analysis of a lawyer's craft. We've covered their public reputation, their official license and disciplinary record, their peer and client reviews, their track record in court dockets, their public profile in the news, and the critical gut check of the consultation itself. We've dissected the fee agreement, and finally, we have examined the very essence of their work product. You are now equipped with a complete, 10-step, forensic toolkit for vetting a legal professional. You are no longer just a potential client, vulnerable and uncertain. You are an informed consumer, a savvy executive hiring a critical team member for one of the most important projects of your life, your future. This process isn't about finding a mythical, flawless lawyer. They don't exist. It's about finding the right lawyer for you. It's about finding a competent, ethical, and dedicated professional whose skills are aligned with your needs. It's about mitigating risk in a situation where the stakes, your money, your family, your business, your freedom could not be higher. The time you invest on the front end, these 10 steps of deep, thorough vetting, will pay you back 1,000 times over. It will save you from the financial ruin of hiring an incompetent attorney. It will save you from the emotional agony of being represented by someone who doesn't care. And it will give you the confidence that you have put your trust and your future in the right hands. The law is a labyrinth. Don't enter it with a guide you wouldn't trust with your life, because sometimes that's exactly what's at stake. Choose wisely.